Greatest of evenings, mornings, or afternoons, everyone. My name is Mario A. Reed, and I'm the managing law partner for the law offices of Mario A. Reed. We do estate planning, and one of the number one questions that we get asked related to estate planning is, what's the difference between a trust and a will? Well, there are lots of differences, and a lot of people think that it's you either have a trust or you either have a will. However, in an ideal arrangement, you have both. And that's because a trust does very different things than a will. A will takes care of you, the person. I want my body donated to science. So that goes inside of a last will and testament. I also don't want for any in laws to get anything. If my daughter gets married, I don't want for her spouse to be able to come and contest what's going on with my estate. I also want to make it clear that if anybody tries to fight my wishes, I want for the court to give them nothing. All of those specific terms are a part of my last will and testament. However, my revocable living trust is a totally separate document that does totally separate things. Many people focus on a revocable living trust and thinking that it's just to prevent probate court. And while that is definitely one of the tremendous benefits of a revocable living trust, that is not really the purpose of a trust. The purpose of a trust is to control property from the grave. And I'm going to repeat that. It allows you to control property from the grave. One of the things that is most beneficial about a trust is that you get to specify what happens with your assets after you have died. A lot of people think that a will accomplishes that, but it doesn't do a very effective job. If I leave my property to my daughter via a last will and testament, when I die, my daughter will then have to go to probate court, which in Cook County is at the Daly Center on the 18th floor, and ask a judge to enforce the will in terms of appointing her as the independent executor. And then she has to go through the process of transferring the property using what's called an executor's deed, and then getting it recorded, paying the recording fees. But she had to pay legal fees in order to go to probate, because in probate, you can't represent the estate because you can only be an attorney in order to represent someone else. And as an executor, you need someone to represent the estate of the deceased individual. The trust allows for you to avoid that process. And while that's fantastic, it's not the real value. The real value of the trust is that not only do I get to say that I want the property to be transferred to my daughter, I also get to specify that if she decides to sell the property, the proceeds are to be used to purchase an investment product. And in my case, I want it to be 5 different investment products. So let's just use a hypothetical. Let's say that the property sells for $750,000. If I specify that I want for it to go to my daughter, she gets $750,000 all at once. And let's say that she's in her mid 20s. What do we think that a 20 something year old is going to do with $750,000? Well, knowing my daughter and how responsible she is, she would invest it and then she'd live off the dividends. But I'm not going to leave that to chance. So inside of the trust agreement, I now specify that if the property is sold, so I'm giving her what's called autonomy and discretion to decide, is she going to keep the property or is she going to sell the property? If she decides to sell the property, then the proceeds are to be invested. And how that works is that the title company that handles the sale of the property is going to issue a check in the name of the trust. Then the funds get deposited into a brokerage account that's already set up in the name of the trust with Charles Schwab. Once those funds have cleared, and in this instance, we just have it wired, so it would clear right away, then approximately 20% of those funds is to be allocated to a variety of high yield dividend income paying funds. So 20% would be allocated to ULTY, 20% would be allocated to RBLY, 20% would be allocated to PLTY, 20% would be allocated to HOOY, and 20% would be allocated to MSTY. And by structuring in that way, the next thing that's listed as a part of the trust agreement is that the beneficiary, my daughter, is to receive 50% of the dividend payout each and every week. So let's do some quick math, and I'm going to share my screen so that way you can see exactly what that would look like. Because for a lot of us, we need to see the actual numbers. So how it would work is that the $750,000 gets deposited, gets wired right into the brokerage account. The title company handles that part. We're going to then divide that by 5 because we're going to break it up 5 ways. So that translates to $150,000. So presently, and I'm going to now go and take a look and see what these dividend funds are paying out this week. Well, you know what? I can't do it this week because RBLY isn't paying just yet, but we're going to use MSTY. So MSTY is the high yield dividend paying fund based on MicroStrategy. And that fund last week paid out a dividend in the amount of, and all of this information is online, so I don't want anybody to think that I have a special calendar or anything like that. You just go right online and type in MSTY dividend announcement 2025, and then it'll bring up the most recent dividend. You can also just search for MSTY dividend history. So I'm going to do that, and that's through stock analysis. So last week, MSTY paid a dividend of $1.18 per share. And as of last week, let's say that we would have purchased those shares on last Monday, MSTY stock performance is going to allow us to see what the stock price would have been. So approximately 5 days ago, let's do a month so that way we can go back to the Monday. So going back to a month ago, if we go back to Monday of July 28th, the share price was $20.75. So then what we would do is we would take the $150,000 and we divide that by $20.75. That would have resulted in a purchase of 7,228.91 shares. So then that following Friday, immediately thereafter, we would just multiply that number, the number of shares, by the total dividend payout, which was $1.18. So times 1.1835. Now, the dividend payout was $8,555. So based on what's in the trust agreement, REL gets 50% of that amount. So we just divide that number by 2. And the first week after it is that the property is sold, she's getting a payout of $4,277.71. The other $4,277.71 is then used to purchase more shares of MSTY. So now she doesn't just have the 7,000 that we saw for the first payout. She's added however many more shares. And let's say that the price dropped down to, so after the payout last Friday, which was, what was that? August 1st, the share price dropped down to $18.87. So now we're going to divide the $4,277.71 by $18.77. So now she gets another 227 shares. Those 227 shares get added to her existing share count, which is 7,228.91. So plus 7,228.91. So now she has 7,456 shares. If next month, the month of August, MSTY pays out, let's say $1.50, we're just going to multiply 7,456 times $1.50. And now her dividend payment has went up. She gets half of the $11,185.21. This continues for the rest of her lifetime. When she passes, it then goes to her children if she has them. If she doesn't have children, then those payouts then get divided up amongst my 8 siblings. And if any of my siblings aren't here, it goes to my nieces and nephews and then down to their children. And it continues perpetually for the rest of time. Unlike with the last will and testament, where you simply specify you want for the house to go to your child, and then they decide what happens. And if they sell it, they take the money and they spend the money. I have actually created generational wealth that is going to multiply and compound forever. I do not have to worry about what Ariel does with the $4,000 in the first week, because if she blows all of it, next week there's another payout coming, which would be from RBLY. MSTY is part of Group D, RBLY is part of Group A, PLTY is part of Group B, HOOY is part of Group C, and it's a loop that continues to go. ULTY is currently a weekly payer, so she's going to get paid additional funds from that as well. What I've done is I've created a self-sustaining, never-ending money creator in the form of the asset which I owned. What allowed me to do this was the Revocable Living Trust. The value wasn't necessarily in keeping Ariel out of probate, because while that is valuable, oftentimes someone can go through the probate process for as little as $5,000. So it's not the end of the world if someone does have to go through probate. It's inconvenient, it's costly, and it's cumbersome in terms of how much time it takes, but it's not the end of the world. But where the real value of the Revocable Living Trust comes in is that I've now made my daughter a millionaire within a year's time, and then a billionaire within 10 years' time, simply by having a plan that enables me to control the property from the grave. That is the value of the Revocable Living Trust. You're able to ensure that your plan and strategy gets carried out, and it's going to continue for generations to come. It is one of the easiest things that you can do so as to ensure that your loved ones are set up for life, even when you're no longer here to protect them. The key is that you have to put the plan in place. And once you've done so, that plan is now going to be facilitated and administered by the people that you've chosen that you trust most. The other great thing is that you've now made it easier for them to know what your wishes were. So instead of one family member saying, I don't know why it is that she's doing that with that money, her father wouldn't have wanted that. That's not true. It's clear as day as a part of the Revocable Living Trust. The other part that it enables you to do is it keeps those finances separate. So my daughter doesn't have to worry about dealing with any of the tax consequences herself, because the money is not going to her. Now, she is going to need to retain a certified public accountant or a tax preparer to prepare the tax return for the trust, but within 6 months' time, she will be on average receiving between $50,000 to $100,000 in dividends. So I'm sure she can afford to retain a quality certified public accountant. There is going to be tax liability. Just because it's in the name of a Revocable Living Trust doesn't mean that it magically eliminates the tax liability. It's going to continue. It does exist. However, you've created more than enough revenue and windfall to be able to offset whatever tax liability comes along. You don't have to just set it up for one person. It can be for multiple people. You also can stipulate what must happen in order for the beneficiaries to receive the payouts. For my siblings, in order for them to receive their payouts, they have to participate in at least 4 family functions for a minimum of 2 hours throughout the entirety of the year. If they fail to do so, their portion then goes to their children, so long as their children have met the requirement to participate in that family function on 4 different occasions for at least 2 hours. I've done this intentionally and deliberately because we oftentimes hear that when somebody who really kept the family together passes away, the family doesn't stick together. Well, I'm incentivizing and I'm financing them continuing to do that. The trustee can use the funds from the trust in order to throw the event, have a huge party, rent out a hall, have beverages, have food, bring in entertainment if you all like. All of that is being financed by the wealth that I've created. So many of us here, you need a trust, keep your family out of probate. But I want to stress to you, that's not where the real value of a revocable living trust comes in. The real value comes in being able to specify a specific plan that has to be carried out that creates true generational wealth. And generational wealth isn't just passing my property down to my children, it's specifying if the property is sold, the proceeds are to be used to create capital that is going to perpetually grow in perpetuity. And you get to determine what that amount is. We have some clients who take 50% of the proceeds and give that to the beneficiaries right away because those individuals are older. So they don't know that they're going to live all that much longer. And then the other 50% is invested so as to continue that generational wealth perpetuation. By setting it up this way, you don't have to worry about dealing with what the Vanderbilts dealt with, which is the first generation back in the 1800s built up a tremendous amount of wealth, one of the wealthiest individuals of the 1800s. His son continued to move that legacy forward and actually appreciated that wealth, appreciated it as in both gratitude and appreciated as in built it up to be more. But the third generation did not do what they were supposed to because there was no plan in place. And they lost all of the capital from the grandfather from the 1800s. They lost one of the most incredible estates that the state of Tennessee has ever seen. It's now controlled by the state of Tennessee and it's used as the equivalency of a museum, but it should still belong to the Vanderbilt family so long as the initial creator of the wealth would have used a revocable living trust to control the property from the grave. That's the value of a revocable living trust. And it's something which each and every one of us has the opportunity to do. It's not something that's exclusively for the wealthy. It's not something that only rich individuals take advantage of. Every single one of us over the age of 18 should have a revocable living trust in place. And by doing so and making sure that you have a clear, deliberate, thoughtful, and intricate plan in place, it will guarantee that anyone who comes behind you will never have to work a day in their life unless you want them to. And you can specify that in your trust. I want to thank everyone for tuning in. As always, our commitment is to education. That education means that whatever it is that's coming up within the practice, we're going to bring that to you all as the viewing public. Please feel free to like and share this video. And if anyone has any questions, they're always welcome to attend our workshops. The second Sunday of each month, we presently are at Unity Christian Academy in South Holland, Illinois, from 2:30 p.m. until 5 p.m. You can find the address on Google. Once again, it's Unity Christian Academy. On the first Thursday of several months up until the end of the year, we are at Visions Odium from 6 p.m. to 8 p.m., which is at 119th and Loomis. Those events are free and open to the public. If you know somebody who's interested in hosting an outreach, or if you're an educator in a junior high, high school, or community college, and you would like for our office to come out and present this information to the young minds that you are doing a fantastic job of molding, please reach out to our office. You can email Mario, Mario, Reed, Reed, at outlook.com. You can also find us on Google. Just simply search the law offices of Mario A. Reed. But above all else, we want for you to not just get educated, but apply that, because knowledge is only power when applied. So have a great one. Take care. And thanks so much for tuning in, everyone.